Okay, now we'll have responses, maybe starting with Cosmin.
All right. Thank you very much for your very, very, very interesting reading of my reading. So thanks a lot. I would say, in order to answer a bit, to explain myself more, this paper is the intersection of, let's say, 3 or 4 projects, which I think it's an important moment. It marks an important moment in my own project because it's the moment when I for the first time I'm really trying to get into the question of Romanian Holocaust, and I would say the first level of my project it's related to as I said, to establish historical genealogy of states. Of the state of exception, or forms of state of exception in the Romanian context, starting with the interwar. Then the second level of my project is related to the question of the Holocaust and the existential question it raises for the legal discourse, in a sense in which, in legal theory, let's say that you have the paradigmatic debate between Fuller and Hart around the question whether the Nazi law would have been, and you can apply this discussion also, mutatis mutandis, to other authoritarian or totalitarian legal systems, whether this kind of legal systems have been, well, completely lacked law in this kind of forms. They were Fuller, this is Fuller's idea, or Hart, which says, well, basically that there were places of law. And the question is whether this, and I think this is very much related to what I'm looking at, the military dictatorship, whether in itself it was a place in which law was overrepresented, or it was a place which was completely devoid of law, which of course, as a legal historian, you can never agree with the first thesis that this place was or the second thesis that these places were devoid of law, because you always have traces of administration orders, you always have legal statutes and so on. So there is also another level of my project, and this is related to the question of anxiety. That's why I use this title, and here I give it a slightly different reading to the one very interesting reading that you propose. And to me, the question of anxiety, here I'm using it in a let's say Lacanian psychoanalytical jargon, in a sense in which for Lacan in Seminar 10 he says the proper reaction to any form of danger for the psyche is flight. And anxiety, it precisely represents this form in which one encounters, or the psyche encounters, the traumatic real, and it withdraws. And it's precisely what I think happened with these post-war trials. Because if you ask yourself, those communists in the communist movement, most of them, they were part of the democratic bloc. They had the possibility, they had been victims of fascism and of military dictatorship. Some of them, they have been interned in internment camps. Some of them, they had relatives or friends or comrades who died in extermination camps. But still, they wanted to keep with the line of Moscow, which was gain legitimacy, use this trial as to gain legitimacy as much as you can, and forget about everything. So I think this is another line which is important here. So this I think it is the way in which and the main problem related to the state of exception is whether the legal system got back from that state. And it's still an open question, I would say. We can talk about a return to legality or to constitutional practices after 1989, 1990, or 1991. But still, this question in the form of the legal discourse and looking at the history of the legal discourse throughout starting with the 1920s, 1930s, still remains open because something dramatic happened during that moment in time. So that's why I think it's really important to focus on this dramatic eruption of violence inside the legal system and the state's frameworks.
Thank you. Thank you very much for your comments. They were greatly appreciated. In response to the first question asked what the paper is about. Is it about politics of the legislature or politics of the courts? And you rightly point out that there is an important distinction. And I would say that the theoretical framework and the methodological framework can be applied to both, although researchers would naturally want to focus on specific aspects because the work of discourse analysis is very labor intensive. But I think there are times where it really makes sense to look at the interplay between the two. For example, looking at discourses that arise in parliamentary debates and the rulings of the Constitutional Court, which make rhetorical moves that alter the discourse in important ways. So it's possible to view these separately, to view them together in terms of how they interact, and also to bring other actors into the picture as well. In response to your observation that the inventory mentions Poles, the Polish nation, etc., but does not make mention of ethnic groups or nationalities, this is absolutely correct. And I found that very striking. That was quite interesting to me. I constructed the inventory based on the subject positions that appeared in the legal documents themselves. So I simply listed what was present in those documents. If ethnic groups were not mentioned in the documents, then they did not appear in my inventory. And I do think it's interesting that they were left out. What this means, I don't know. Possibly it suggests that the discourse is in part about defining national identity. That may not be the primary purpose, but that may be an interesting kind of sub-discourse that's feeding into this. And I think that future researchers could investigate what subject positions cluster around the subject position of the Polish nation. In other words, what other groups can be associated with Polishness and what groups are disassociated with Polishness. And I think when we investigate this question, it becomes easier to understand why some of these debates are very emotional. Thank you.
I had actually negotiated whether to include a comment on the citizenship or not, and had left it out because I expected already that question to come. And indeed, I have an ambivalent attitude towards this, because on the one hand, I know that Lavinia and others have included citizenship legislation among lustration measures. My first reaction is that I heavily disagree, because they were never, at no point, if you go into the records of how they were drafted and how they came into being through parliamentary debates, etc., they were never meant as aiming at former KGB agents or people involved in the communist regime. They were simply based on the legal continuity claim against Soviet-era immigrants. Because, de facto the state had continued to exist, so they were immigrants and they had come in an illegal context, and so they should now apply for citizenship. That was sort of the logic behind this. However, Lavinia is right to notice that in its effect, it cleaned much of the administrative apparatus of certain people, thus allowing the governments in Latvia and Estonia, relieving them of a certain amount of need to maybe engage further in purchase or in vetting. And And so in that sense, in its effect, it had some sort of lustration effect. So if we would take a very radical approach to the citizenship law and say, okay, let's say, you know, if it's about defining the perpetrator by state law, you know, then by virtue of having the legal continuity claim, all Soviet-era immigrants are as such collectively defined as occupants, as such as perpetrators, and that indeed would blacken both boxes enormously. But you know, by doing that, we would then be unable to differentiate what measures against actual, you know, members of the KGB were taken. You know, that would just blur the whole picture. And you know, not to talk about this not being then easily comparable to other post-communist cases, but I think it would not serve us very well. I mean, one has to acknowledge that citizenship legislation, you know, was there, but it was fundamentally only under this very radical interpretation can it be seen as a form of transitional justice. Then what you said about Lithuanian language law, I disagree with that. It's not transitional justice. It's you can call it nationalism, you can call it very strict linguistic laws, you know, in terms of names having to have a certain ending, because otherwise you can't flex them in the Lithuanian language, you know, whatever you call it, but it's not related to any wrongdoing in the past or, you know, to any kind of misdeeds that happened that have to be adjudicated or somehow redressed. And so I would not involve that. That would really blur the kind of definition of transitional justice enormously.
Okay, and I've been informed that Anna Luleva is present right now, and so she can also respond to the commentary. Yep.
Thank you. Thank you for the opportunity to be part of this panel and to hear very interesting comments. Thank you very much. Yes, of course, the problem of law and justice is broader, and not only the part of my presentation is a small part of this problem, but I would like to say that I'm an anthropologist, and for me it's important to see how this law, how this legislation in the transitional period was accepted by the people, and how they experienced these two laws about the rehabilitation of victims, and the second one was about the communist regime as we were this. Excuse me. It was about proclaiming the communist regime as criminal, past 2001. And for me it was very important to see how all this discourse about this law was accepted by the ordinary people, by the victims of the regimes, by the formal nomenclature. It expressed also the new situation as a sort of terror, a sort of repression by the new globalized rules and new elite and so on. So from this perspective, I would not agree that it is important to see this legislation only as a discursive realm, but as a real experience by these people. I think it is legitimate to see it as injustice. Many of my interview partners thought of this with examples of their life stories, and I agree. Thank you.
Okay, thank you. So now we have just a little bit over 20 minutes for questions from the audience.
Thank you very much. I just wanted to, it's a quick question to Eva-Clarita. Did I understand you correctly that you said that the difference between the transitional and the retrospective is that in the retrospective category there's no impact on contemporary politics?
Well, in the sense, there is no direct impact in the sense that people who are still involved in political life are being excluded from the system, you know, in the way that transitional justice would do. When it comes to perpetrators, it has, of course, an impact if you talk about discourses, historical discourses, about narratives of the past. Then, you know, in an indirect way, it has an impact. But in terms of the immediate impact lustration has or vetting procedures have on people pursuing a particular career or, you know, taking up positions in the public sector, that kind of impact is not given when you go after people who did misdeeds 50 years ago.
Okay, so I would just suggest, I think, that there's tension here in the presentation between, and it's actually, it applies to the panel in general, is that the relationship between the legal and the identity issues, which came up in all of the papers, and where what you call retrospective, which is a very neat distinction, a delineation. But I think that the whole point of doing that retrospective is precisely because of the enormous impact that it has on society through identity. So I think that there's some kind of a formulation, but I think it's very interesting that what the distinction you're making.
Thank you. I sympathize very much with you because I've been doing some work in discourse analysis on the Romanian side, and I know it's very time-consuming and it's a thankless job, yeah? But I would say I have one comment. Discourse analysis seems to be very ignored method in North America, but it's very prevalent in Europe. Every other Romanian that I know, except Cosmin, is involved in some kind of discourse analysis of transitional justice. You know, so I would be careful not to look only at American produced literature. Then Eva-Clarita, you criticize me, I have to respond, yeah? Now, I think this is really interesting work, and I know that you've been doing work along these lines of categorizing, and it's really interesting. It's a very good addition to the literature, but also I have some comments. I don't see in this table a lot of measures that I consider transitional justice. Rewriting of history books, truth commissions, access to secret files, memorialization projects, apologies, condemnations. Okay, you have a little bit there. So I think also diminishing the pensions of former prison guards, which was a topic of research and in both Romania and Poland, I know, yeah? So I think you know, a little bit needs to be done to be a little bit more inclusive than we know Brian Grodzki, we respect him, but I don't think that he really got the gist of transitional justice. Then that was my first comment. The second is, I would say you need, going back to the first table, I think I see another dimension that should be added. Yeah, you have perpetrators and victims, then the type of transitional justice measures adopted and time. And I would say state, non-state is not there and should be, because it really matters if, you know, it's the state who should be responsible for satisfying the demands of transitional justice, or we can involve also some non-state civil society actors in this business. And for some measures, we cannot involve the civil society actually, or at least we can involve it only to a certain point. Trials. Is only the state can be involved in trials, yeah? Only the state can be involved in rehabilitations. So I think state, non-state is also important. And my third comment is that I don't really see how establishing a legal framework is transitional justice, is transition. But I would include it on the democratization, or on the very broad category that is not really fundamentally concerned with righting the past wrongs. Yeah. And I think Cosmin's paper also raises one concern about your categorization here. It shows you that perpetrators can be victims, and victims can be perpetrators often. And this is the case not only in Romania, but also in other Eastern European countries. So then, you know, the categories maybe are too neat to reflect the reality. Cosmin's paper was fascinating. I've done some work in this on Romania. I know a little bit about it, and I think it shows, it raises the question: what do you do with trials that are tainted? What do you do with these trials where the communists were not interested in justice, but they were interested in legitimacy? And then the broader question is, can we engage in transitional justice in non-democratic settings? And I think this is, you know, and it's relevant also for communist Eastern Europe, but other cases in the world. The first Truth Commission that is registered, and Priscilla Heiner included in her book, is Idi Amin's commission, you know? So I think, you know, I'm looking forward to your comments. What do we do with these great cases? Thank you.
Do you want to respond briefly, or?
Well, it's quite a lot of things. But I can, I think, very briefly comment on history writing or history textbook writing. Well, what we did here, one should not forget that we have the categories of perpetrators and victims. You know, what we do not do is rewriting the narrative of the state and the nation. This is not part of this matrix. It overlaps into that direction. And this is the thing with that box, to very carefully determine what measures fit in there. They should be directed at victims. So they are remembrance projects that aim at the victims, at acknowledging the victims. They are, you know, opening the files for individuals to see their records. You know, these measures, also the truth commissions that fit into here, only to the extent that they research what happened, you know, identify victims, locate them, etc. So in that sense, this last box overlaps a lot, both into political myth-making as well as into social memory construction. You know, and it's hard to delineate, but we are very much aware of that, that it's just that within this box, you know, this is the beauty of these categories, that, you know, you can focus and you can exclude certain things. And textbook history writing clearly is not victim-centered in that sense. In terms of state, non-state actors, yes, of course. I mean, especially on the symbolic level, there are lots of non-state actors involved. But our purpose was to define patterns of truth and justice, you know, pursued by states. This is the purpose of this kind of comparative project. So, you know, otherwise, if we now include a non-state-state dimension, then we end up in this kind of Elsterian laundry list of, you know, all sorts of categories and decisions and whatever. I don't know whether that is so productive in really fostering comparative analysis. And then legal framework setting, of course, what we mean by that is really in relation to past crimes. You know, of course, not the general writing the criminal law or something like that. But in this box, it refers to defining the crimes that have taken place in the past. And so in that sense, it belongs there. It's part of that particular transitional justice measure.
This gentleman back here? Oh, well, yeah. Go her first and then, yeah.
Thank you very much. I really enjoyed the presentations. I'm wondering what happens when we put Ila Rossmiller's paper together with the Eva-Clarita Pettai's, in terms of seeing the perpetrator and the victim not as pre-existing categories, but by categories that are actually produced by the laws that you then categorize, which then also allows some kind of neat gray or whatever green spaces in between and beyond. So in part this is a question of what do we lose by having this clarity of lines and categories, and does it actually help us we have more clarity, then we can compare better. But thinking about the loss of it, and then the question back on the issue of subject positions is, so what are some of the effects? Okay, you've just done the inventory and it was really exhausting, I can see that. But do you have any sense of what the effects are in terms of which actions become possible, or who can speak about what, if you can occupy certain subject positions, or at least can try to, for as long as you're not being kicked out of it by some law or the other?
Thank you. That's a very interesting question. That's the topic of my dissertation, and I hope to meet you at another conference next year and answer that question.
Okay. Can we get this gentleman back here?
Andrzej Kopczyński, ja mam do Eli
I have a question to Ela Rossmiller, and I would like to ask this question in Polish, if I may. When we talk about ethnic groups, you will not find anywhere in any Polish legislation any differentiation, because the Polish constitution does not differentiate that the Polish nation is made up of Poles, Germans, because all of them have the same rights and obligations, so there will be no differentiation. So that is why one exception is electoral law, where a group of minorities, a German minority to be specific, has 2 mandates regardless of how big this German minority is in Poland.
I appreciate your comments.
I have my comments and questions are for Ella as well, and I think I have one for Eva later. So they'll be hard, but they come from a position of solidarity and sympathy for the discourse analysis. So first, you use a lot of words like deployment in your paper, and you refer to politicians. And I want to ask you if you're introducing agentic language to discourse analysis, and you're moving away from structure of discourse. And I want to know, you're not using the word constitution, you're not using the word interpolation. Is this intentional? And what work does this do for you? It is something very valuable in discourse analysis precisely because it's structural, precisely because it works as a kind of transparent frame in which we all operate. So when Laclau and Mouffe talk about building of the wall, and there is a brick and there is a bricklayer and a wall and a brick, they don't really have agency insofar, especially the materiality of the brick doesn't have any agency. So is this deliberate move? The second, in your paper, you struggle between choosing subject position versus identity as a term. I would advocate sticking with subject position precisely because it's odd. Identity politics, it's my field, is perennially confused with the word identity as a category of practice and analysis. A subject position doesn't introduce that confusion. We know we're speaking with the analytical frame. And the second question perhaps builds on the previous one, and that has to do with the fact, what are the dynamic articulations between your subject positions? What are the hierarchies? What is happening between them? An inventory is somewhat static, but what is it? What happens to them, and how do they work together? Mm-hmm. And my second question, and this is to Eva-Clarita Pettai, I want you to perhaps to push you a little bit to speculate. Transitional justice measures are ways of uncovering usable pasts. So I would like to have you speculate on a collective memory production. What is accomplished by the fact that we are jumping from transitional to retroactive measures? What is this jump, temporal jump, doing in the production of usable pasts?
Shall I go first? I have to think a bit more. Thank you very much for your questions and comments. I will attempt to respond here, but I hope that we will have more time to converse about this in depth, perhaps during the break. I can tell I'm talking to an experienced discourse analyst. In terms of the deployment versus the constitution of subject positions, in the literature that I've read, I've seen both of these terms used, and your question is well taken. I will say that it was not a deliberate move on my part. I am remaining agnostic for the time being, but this is a very interesting question that I'd like to discuss with you more during the break. I also very much appreciate your comment that I stick with the terminology of subject positions. It's not intuitive language, whereas political identities seems to resonate more with people, but I find, as you have found, that when I use the term identity, it's consistently misunderstood. People think I'm talking about something that I'm not. They think that, you know, I'm talking about mental schemas, psychological self-construals, public opinion. I'm not talking about any of those things. So I do appreciate that affirmation. And then finally, you asked what are the hierarchies and the dynamic interactions among these subject positions. That's a fascinating question. I recognize that the inventory is static, and this inventory is really, I mean, it's a first rough cut. It's a starting point for future research, and that's really all it is. In my previous research, when I was looking at some of the secondary literature, I found that the same types of subject positions were being invoked over and over again, and I didn't really have a sense of whether these are the main things we should be focusing on, or if this is just simply what has been done in the past. And so I created this inventory just to get a much broader picture of the types of things that could be examined in the future. And so I will respond to your question by saying, that's a fascinating question. I hope to answer in my dissertation, and I hope to see you again next year at a conference and answer your question. Thank you very much.
If I understand you right, then your question about the usable past is very much a question of what is transitional justice done for, right? So it's sort of taking transitional justice as the independent variable. See, you know, what effect might it have, and indeed, you know, the effect of sort of more transitional justice in the conventional understanding is, of course, primarily a political intention of locking in the democratic transition, of securing, you know, the democratic transition. Whereas the retrospective one is very much, as Elazar pointed out, more on the identity creation level, sort of creating a narrative with which as many people as possible can identify, you know, especially in cases like the Baltics, you know, where state building was very much an issue after the end of communism. You know, of course, this very strong focus on retrospective truth and justice was aiming at creating a victim narrative, creating, you know, a strong identification. And so, in that sense, creating a usable past. So that would be, I think, the differences. However, of course, transitional justice can also have that kind of more identity-focused use. Well, of course, not talking about the later decades is avoiding the question of not necessarily guilt, but co-responsibility and these issues, you know. That is quite striking indeed, that not just in the Baltics, but I think especially in the Baltics, that there's very little talk about the 60s, the 70s, you know. That is like a black hole that was, you know, we were all secret resistance fighters, that's it. So yeah, in that sense, the not talking actually has more effect than, yeah, the talking.
Okay, we've got just a little bit less than 5 minutes, so maybe one or two more questions.
Moje nazwisko Ryszard
My name is Ryszard Karpowicz. I represent Polonia, a journalist. I have a very Polish question to our panelist, who is a specialist on the law, to the commentator. So, what is the context of the subjective application of human rights in Strasbourg? My point is the recent judicial decision that differentiated, well, whether the Katyn massacre was a genocide or just a war crime. Could you give me any explanation why the Strasbourg Tribunal, the Court of Human Rights, said that it was just a war crime? It was not a genocide.
I'm not sure if I'm actually empowered to, I understand Polish, but I prefer to answer in English for the audience. I'm not actually sure that I'm competent to answer your question on Zbrodnia katyńska, and we shouldn't forget that Strasbourg Court is not the constitutional court in the Council of Europe for almost 50 member states. That's the court which has its natural limits and which cannot go really and punishing the states, establishing and clarifying historical record, etc., etc. It is bound by the so-called concept of the margin of appreciation, and there are certain limits to, let's say, the investigation capacities of the court. So I'm not really a specialist to talk on the Katyńska massacre and the recent judgment of the Court of Justice or of the Court of Human Rights. So sorry, that's all I could tell you.
Back here.
Thank you. Just a short remark about the obligations and rights of national minorities in Poland. Well, it's not that German minority has the right to always have 2 members of the parliament. It's actually for all national minorities in Poland. Political parties registered by national minorities do not have the election threshold in the election to the parliament. Actually, as far as I remember, 6 years ago, there was only 1 member of parliament from German national minorities. Other minorities are simply too small to have even 1 member. Obviously, national minorities has also quite a number of rights in other fields. For example, education. Even some people pass, instead of Matura exam from Polish language, they pass Matura exam from the literature and language, for example, Ukrainian or German. It's possible. If it comes to the issue of transitional justice and national minorities, well, on the one hand, we can say that there's no need for differentiating Polish people or people of other ethnicity, but we do have an issues like action called Wisła, so expropriation of people of Łemko origins. So there are fields where maybe those differentiation would be should exist. Thank you.
Thank you very much for your comments.
Okay, thank you for all the good comments and questions, and please join me in thanking our panel. Okay, and I've also been asked to let you know that after the panel at 3 p.m., which is now, lunch will be served in the room next to ours. Okay. And thank you for coming.